So estate planning, the plan's only as good as the customer alignment that it has to it. And clearly in estate planning and doing business with military families, there's different considerations, partially because there's so many different types of military families to deal with. Really lucky I came across an attorney who, as a good part of his practice, works with military families, both veterans and current service members. He himself, the terminology is not was a Marine, because once you're a Marine, you're always a Marine. So he is a Marine, just not carrying around a gun and not in his camouflages, but currently an attorney in San Diego and the Inland Empire. Paul Hilton, welcome to our call today.
Thanks, Bill. Good to be here. Appreciate it.
And I know I met you through one of my good friends who was Navy servicing Marines in the Chaplain Corps. So thank you for your service. So I know we mentioned previously when we've talked about the special considerations when dealing with military families. And then obviously there's veterans and then there's, current service members. Can you kind of hit some of the high points? Where's some of the particular concerns you have when you do an estate plan for current service members versus, say, a standard customer?
Well, for current service members, one is convincing them that they need to do an estate plan, and a lot of times, if a service member hasn't really built an estate yet, he may still be fairly young, not have a family, and stuff like that, and he hasn't bought property, doesn't have equity, may not have a brokerage account, and instead he has a thrift savings plan or something like that, and is potentially a military retirement. Those are all things that an estate planner needs to think about and advise on. They may not need a trust, but they certainly do need a will. They certainly do need a durable power of attorney in case they were disabled, and they need counseling on how do they want those assets that will pass without probate. How do they want them to pass? How do they set those beneficiary designation forms in such a way that they do go where they want, when they want? Now, if they're a service member and anybody in their family is disabled or has some special need that they shouldn't be distributing assets outright through a beneficiary designation form, then you got to start looking at things like putting it in and conduing it. That's kind of a word of art, but anyway, conduing it through a trust where it has different specified instructions. Of course, then when that military family retires or they just start buying property, a lot of military members, as they go about their different duty stations, I know a lot of Marines that did this, especially Marine officers, they'd buy houses at these different duty stations and then rent them out the next time they move. So now they have all these houses in different states, and those, if those are titled in their name or the service member's name, the service member and his spouse's name, come into all sorts of considerations about probate in multiple states if they were to pass away. Probate, ancillary probate proceedings, main probate proceedings, and then of course some states have community property laws, and some states are common law, so it can get really complicated. And at that point, a military member needs that kind of detailed and thoughtful planning. And then, of course, then the veteran who is now out and may be disabled, and there's maybe veterans benefits and retirement pensions. You have to consider all those things. You ask for the highlights, and those are really the big muscle movements. There's other stuff in there, but there's a lot to really think about with a veteran and a military member.
Yeah, it's varied. I think that there's a wide disparity from the first-time homebuyer, young Marine, starting his family, versus the officer who's been in 20 years or more, maybe maybe a spouse also military, maybe not, relocating kids, rental properties, more established finances. And I think one of the unique things you brought up is multiple jurisdictions, right? I have a friend who's getting divorced in California. They have assets that were in maybe joint, maybe not joint in Alabama. So, what laws prevail? You have probate law in a state, you have divorce law in another state. How are those estate assets, obtained? And different jurisdictions have different rules. So you practice, as a practical matter, you only practice law in California?
Well, yeah, absolutely. I'm licensed in California, and so I produce state plans under the laws of California, and can deliver those throughout the state. I actually have done those via Zoom, via a virtual type of thing, for people who in other states who wanted an estate plan that was crafted under the laws of the state of California.
I imagine you must from time to time have to network or have questions, or administering estates, get in contact with attorneys in different states. So I would think just the nature of career service members is just so different than non-service member Americans. True? Is that something you get involved with? Or
Yeah, not as much as you might think. There are certain things that you do have to do. For instance, if one of the big things, if somebody really has a sizable estate and they have a potential they need liability protection, then you're into looking at asset protection trusts and domestic asset protection trusts. And then as an attorney, you're going to have to work with, for instance, I can't build a Nevada trust. I can build it, but ultimately to execute it takes a coordination with a Nevada attorney. But those are very important. Those can really help a serviceman, help anybody with asset protection if in case they're likely to get sued. If slips and falls or wrongful deaths, any of those types of things. If you want to protect your estate, those domestic asset protection trusts are incredibly important.
Just some real quick housekeeping. This is Probate Weekly. We do this every Thursday, 4 p.m. Pacific time. We live stream it on YouTube, Facebook, and LinkedIn, and record it as well. I'm Bill Gross. I'm a real estate broker and national team of probate experts out of Los Angeles, California. And our guest today is Paul Hilton, who is an attorney based in San Diego / Inland Empire, so I guess southern eastern portion of California. And you can find more about him at paulhiltonlaw.com. And there's a picture of him as well.
Before the beard.
Before the beard. Pre-COVID distinction. So very glad to have us join us. And he's recommended through a good friend of mine who was, I have a friend who went into, at 9/11, it's kind of interesting to talk about today, was inspired. He had not been in the service, wasn't ordained, and became an ordained rabbi and joined the chaplain corps as an officer, entered officers cadet school, and came out an officer in the Navy and serviced Marines as a member of the chaplain corps around the world. Just amazing story. Who introduced me and Paul. So, Paul, I know one of the things you and I talked about that I thought was interesting was a particular type of trust, a domestic asset protection trust, or I think you referred to as Nevada trust. Can you touch on that a little bit? What's unique about that, and what kind of person is interested in that type of protection?
Well, that would be a person that's interested, somebody that's like athletes, entrepreneurs, entertainers, business. I said entrepreneurs, but small business owners. Somebody who is likely to, that has no protection. No C-level, like CEO, CIO, no corporate sort of protection, liability protection. And those are people that if you had someone or somebody that owns several properties or something like that, if somebody slipped and fell or was injured in one of your properties, or due to that's found that's due to your negligence, you may not have felt you were negligent, but a jury could. And it only takes the preponderance of evidence to get there. Then wherever you're sued, then we assume that we're talking about California. I'm a California attorney. A California judgment against you would not, if you had your assets in trust in a Nevada or I think there's, well, forgive me, I'm thinking like around 15 states that have asset protection trust. But what they do, the Nevada law says if you put assets in those trusts, then courts of other jurisdictions cannot, they just ignore it. They will absolutely ignore it. And so a California court, where if you had California property, all the California court would come order the sheriff to take it, to seize it, if you have that, if you're found liable. So that's one thing. Now, even better, of course, is a foreign asset protection trust. And that would be something that's done in the Cook Islands. There's like 6 trustees over in the Cook Islands, large companies, and that's what they do. And those are totally, there's no federal court, there's no state court or anything that will go and take those assets away from you if they're in trust. Now, let's full and open disclosure. Those are irrevocable trusts. They're expensive to build. You've got to have a lot of assets to protect. It's got to make it worthwhile, and they're expensive to maintain. And because they're irrevocable, you essentially don't own that asset anymore. Now you are the beneficiary of it. The trustee divvies it out for your benefit, but it's the compliance factor of it becomes much more difficult. So it's kind of a unique person that needs that sort of thing. They're wealthy, and they're in a highly litigious type. A brain surgeon could potentially be some people, those types of profession, doctors, attorneys, frankly, can be depending on that. So it's just something to keep in mind.
Got it. One of the questions we talked about before was that, and I'm guilty of this, I had a trust done years and years ago, and it's sitting in a box, and turns out I'm changing some accounts. I need to pull it out. And I realize, gosh, I haven't looked at that in how long? How often should somebody who has a trust created review it with appropriate attorney, or at least review the major points? Who are my kids, or where are they? My wife, my assets. Like, when should you evaluate those major decisions, or how often should you have the whole thing reviewed?
Well, you should be aware of it. You should know where it is, and you should be familiar with the contents of it and not just forget it. We usually say every 3 to 5 years you should review it. There's a couple reasons why. One, names may change. Your successor trustees that you really trusted and were close to 5 years ago may have drifted off. They may have moved. You may not have that relationship anymore, and you want somebody else, or you wanted you didn't have a child who was an adult that could step in as a successor trustee, but now 5 years later you do, and that child that you have is now an adult and mature, and you could take it over. They're going to be cheaper than most people, and they're so you look for those types of things. Keep that in mind. You don't have to change your trust just because you change assets. Assets are put into the trust and can be taken out willy-nilly all the time without having to change the trust.
So for those of you listening, first off, if you're watching on the live stream on YouTube or Facebook or LinkedIn, feel free to ask questions as well. We'd love to have you. Also, feel free to put your information in the chat box. We'd love to talk to you and answer your questions. I'd love for you to put in your name, number, what state you're in, what city you're in, will you service business. If you want more business, your contact info, feel free to do that. This is Probate Weekly. We do this every Thursday, 4 p.m. And if you want to register and come live in the Zoom, it's probateweekly.com, and you go to the Eventbrite and sign up and register there, and you get reminders. We can continue the conversation afterwards on our Facebook group, probateweekly.com. Love to have you join there, ask questions. There's an announcement for my swim team. I'd love to have you participate there. And then people post, I post my content there. You're welcome to post any probate related content because if you're interested in getting some views, getting some additional information and asking questions and networking, we are building a national network. We have 3,000, we just over 3,000 members in our Facebook group across the country, attorneys and real estate agents. Feel free to participate there. If you're on the Zoom call, the reason, well, let me back up. The reason why you might think, well, why do you have an estate planning attorney? This is Probate Weekly. As a real estate agent, one way to enter the discussion, I got asked this when we started, how do I build my real estate business in probate? One tactic is be familiar with these concepts, not enough to advise clients, but advise clients you know somebody. Hopefully now you know Paul. And you can quote something he says or go on his website and take a piece from his blog and share that with your customers and advise them the importance of protecting assets, planning ahead, avoiding probate, avoiding the need for conservatorships and guardianships. That's why we're doing this today, is to get you familiar with these concepts, not to do them, but so that you can get in discussions with your clients. As realtors, we all have buyers who bought property in the name of Joe and Mary Smith. Well, by definition, they're not using proper estate planning. I think almost without exception, if you buy property in California, you should have an estate plan and buy it in the name of a trust or some other entity. And so as we talk to sellers, you look at the public records, you'll notice it's titled in the name of John and Mary Smith. You might ask the question, just curious, I know it's titled in your names. Have you looked into getting an estate plan? Maybe they have one and never deed the property into the state, and you can tell them by seeing the public records that's not there. So that's why we're doing this as real estate agents or investors. We want to learn the opportunity to be of value to our customers, because the more value we create for customers, the more money we make. So Paul, I'm sure that you do estate plans and do a good job of them, but I'm sure you also get phone calls or inquiries from customers who have estate plans done by other attorneys where something didn't go right, maybe because it wasn't written properly, maybe because the law changed. But one of the things I see most commonly is the attorney creates a great plan, they put it in the box, the customer takes the box home, even has the name instructions. Don't forget to deed the property into the trust right there in the top of the box. And they never actually put the property in. How often is that a problem? And what's kind of some remedies available to customers in that case?
That's often a problem. And one thing I do, and I think most probate attorney or estate planning attorneys that I know that are worth a salt, they will prepare the deed when they do the estate plan. They will prepare the deed for the residence, for the family home that the client has, and I do this, and I have the client sign it, so it transfers into the trust, and then I make sure it gets recorded. So we get that one thing for sure, definitely into the trust. Now, if they have other properties, we'll do those too. Usually at another fee for it's not an exorbitant fee, but per deed and get those recorded, unless the client says no, I'll take care of those. But then they're gonna have to have somebody else to prepare the deeds anyway. So but if you go out and you get your estate plan done and you buy and your attorney transfers your one property in there, but you don't go and then you tell the attorney I'll be responsible for funding it, and then you don't go and you don't change your brokerage accounts to where they're owned by the trust, and large savings accounts, and they're owned by the trust, and it's usually Joe and Mary trustees of the Joe and Mary Revocable Trust or the Joe and Mary Living Trust dated something. That's usually the way they should be titled, even bank accounts and so forth. So if you don't do that, though, then even though you have this great estate plan, you're going to be, if you pass away, your family's going to be in probate court asking a judge, please, we really intended it to be in the trust, but they kind of messed up and didn't do that. And you've got to show that evidence. And then if you get into a family feud where somebody the trust didn't distribute it to somebody who thought they deserved it or thought should get it. Now they're going to be challenging your probate petition for any sort of property that didn't get named to the trust, that should be handled under the rules of intestacy. So that's not necessarily that the estate plan was done incorrectly. It was just that the funding was not completed.
Well, you said this when we met the first time, and it stuck to me. That's a minimum standard of service, that if you don't at least fund the trust and more importantly, deed the property for the client, then because I just see it so often that they never end up following through. And it's like you buy a safe deposit box, but you didn't put your property in the box. You put your valuables on top of the safe deposit box. They're going to get stolen. And I see that all the time. And so it struck me that kind of, to me, is a minimum standard that I'm going to refer somebody to, is that now the truth is I can help them get the deed recorded. I use services that would do that for me, and I could verify the recording and earn some brownie points for the customer. But why would I want the customer to take that risk just to make me look good? I really want them to get the better service and the attorney. So that's one of the reasons why I was, impressed with you. And there's just a handful of attorneys that give that answer. Many of them will say they don't want to do it. To me, that's really a potential problem. We got a question from the chat box. And I appreciate those of you who are putting your networking information. Welcome to Jen Rice from Washington State, and from Cynthia from Music City, Nashville. Glad to have you here. And I see Felissa, investor all over the United States. Felissa, thank you for joining in. Bob asks, what's the impact of a California resident who passes, but his will was written in Arizona? So imagine an Arizona attorney, he lives in Phoenix, for whatever reason, he moves to California, becomes a resident here, and passes away here. Now the will in California, let me back up. There's different laws in different states. So one thing is, in some states, with the will, you avoid probate. In California, you're going to take your will and go to probate court. There's no way around it with a will, right? So what's the effect of somebody whose wills were in Arizona in California? The answer I know is going to be they're going to go to probate court. Is that will going to be valid? Is it going to meet, does California have unique laws that will make it maybe valid in Arizona but not valid in California?
No, that will be lodged in California probate court. The jurisdiction that will have oversight over that will be where the person passed away. Generally where their residence was when they passed away. If they were still a resident of Arizona and they were just visiting California and they passed away, had a car accident or something like that, it's good to still be jurisdictioned in Arizona. But let's say they moved to San Diego and moved to LA. They brought their will with them. They've been here for a couple of years. They pass away. The first thing you do is you have to lodge that will. It's lodged in probate court. And what the probate judges, the courts are looking for any sort of instruction. What did you want? That they're looking for those instructions, because otherwise they're going to default to California laws of intestacy. So even if it's a Arizona will, that's something. That's and it's very likely not going to grossly violate some California law. They're going to be pretty much the same. So it'll be valid, and in that sense. I wouldn't worry about that so much, but it still does have to be probate.
One of the common challenges that come up for real estate agents is there's a house where they know somebody passed, and the property's deeded in a trust. And there's a party who knows who they think the successor trustee is. Maybe there's a sister living in the house and she believes her older brother is the successor trustee, but the person who they think's the trust isn't admitting to it. They're not providing a copy of it. I know there's certain requirements when the trustee passes, the successor trustee, as far as notifying beneficiaries, I think notifying what would normally be heirs. Can you kind of give us some overview of what should the process look like? And then what happens when the successor trustee is not following those rules?
Well, yeah, the successor trustee, yeah, they're required. There's a number of things they're required to do. They're required to. It's very similar in checklist to what they have to go through in probate, except it's not it's not supervised by a judge. You don't have to pay the probate costs and so forth. So, but you know, it's notify creditors. It's notify. You have to notify the beneficiaries that are named, and you also have to notify what those that would be normal heirs at law. So, because they have an opportunity, they'll have to have an opportunity to potentially challenge the trust if they didn't get anything, and they felt they should have in the trust. They can challenge it. Now, that doesn't mean that they're going to win. That doesn't mean they're not going to waste a lot of money going to court to challenge a trust because the trust said it goes to Bob and Mary and not Sally and Jimmy. Sally and Jimmy are probably going to be out of luck, and so and then if you have a successor trustee who isn't doing the things that the successor trustee is supposed to do, like notify the beneficiaries, provide copies of the trust to the people that are supposed to have it, and so forth, their basic fiduciary duties, and you detect that or suspect that, you can always challenge that. You can challenge that again. It's a lawsuit in probate court. It's a petition to have that trustee either removed, to have the judge give an order that they should do certain things that they weren't doing. So yeah, there's in the end, if things go awry and the successor trustee isn't doing what they're supposed to do, yeah, you got most of the time you have to end up back in probate court. A lot of trusts, though, are written in such a way that if the successor trustee is not performing, then sometimes the majority of the beneficiaries can remove them. Just write a letter, all get together, vote, say you're gone. If they don't step down, of course, you go back into the probate court, and the probate court said, the trust says this, the majority of beneficiaries say you're out, so therefore you're out, and different things like that.
Is the successor trustee obligated to give a copy of the trust to, say, people who might normally be heirs, like children who would, by law normally be an heir, but maybe the trust wrote them out? Is the trustee obligated to give them, or the successor trustee obligated to give them a copy of the trust that says that, so they realize that they've been written out, or whatever?
Yeah, there's a lot of, they have to be given notice of that after the trustee, the grantor, has passed away, or when they are deemed to have incapacity, where the trust becomes the rule by which the state is governed, because then they got to know that, okay, we can't sue according to the laws of intestacy. There's something else that prevails.
I had a client once come to me, and they felt the sibling wasn't, disclosing anything and just living in the property, benefiting from the assets that they thought distributed. And, we came up with a solution, which was, well, just, if they're not going to give you a copy of the trust and they're acting like there's no trust, then assume there's no trust, file a probate, and then they'll object, saying, oh, here's the trust. Now you have a copy. And it seems exactly. Like that's maybe cheaper than litigation is probate. Maybe you get the filing fee may be waived or whatever. Is that a solution? Is that, again, you don't want to fraud the court, but if they don't provide a copy, you're entitled to assume it doesn't exist, right?
Yes. Yeah, absolutely. If you don't know, if you don't have a copy of it, you haven't seen it, even though they may be saying it exists, yeah, you can file the petition, ask to be your own executor under the rules of intestacy, and yeah, then their recourse to shut you down is, oh no, there's a trust, here it is. Okay, let's see the trust. Okay.
Any tips on when there is a property deed in the trust? One of the challenges for and I get this, neighbors will come to me and say, hey, we have this house, it's in our neighborhood. We know the person died. How do we know? Well, the tenant said that, or the housekeeper said that, it stopped coming, or the gardener said that. We don't really know, but we think we know. We like to find out who it is. I go on public records, the property tax bills being sent to the house. That's no help. Any particular clues on how to find who the successor trustee is when a property is deeded in a trust? Looking at the documents to see who the attorney is or the notary. Any other tips you might offer on how to find that out?
No, not really. If you don't have the trust, see, this is the thing that's really important. So when you build that trust and you get it signed off, and this is the advice you should be giving, and I give written instructions to this to my clients. You need to have that document. Make copies of it. Give copies of it to your successor trustees. Have it in a very conspicuous place, so that when somebody walks into your office and you've had your last day in the office, you've had the heart attack and fallen over or whatever, how sad that is, and we hate talking about that. But when that situation comes, that document should be, oh, there it is, or very clear. Say you can't keep it in a safe out in the garage. Well, very clear breadcrumbs to that safe and how to get into that safe. You don't want to be publishing the combination to the safe, because you're assuming you're keeping valuables in there. But it needs to be clear that when you're gone, and you can't answer the questions, it's got to be findable, because this problem that you're talking about happens all the time when people take their trust, they take their documents, they don't properly deed them, they don't, or they take the trust and they hide it, and they don't inform the people that they're going to need to help them, that they're going to need that help. And then so you've spent all this money to produce a trust, to get an estate plan, maybe even done some funding, but your family, your heirs, your beneficiaries are potentially back into probate court, trying to get court orders to get these documents and view them. Now, some people go so far, and I don't do this, but some people go so far as to actually record their trust with the county recorder. The reason I don't do that is because until you pass away, that trust is private. You may not want mean Uncle Jimmy to know that you don't like him and you've disinherited him, because he's going to be angry at you. It's going to make every Christmas or every holiday you get together as a family awkward, right? Because so you don't even want him to know that, and that's why. But once it becomes, you record it and it gets into the county recorder, then people can bring it up and see those documents and review them. And me and Uncle Jimmy, if he's mean enough, or niece so and so, this may be, could be a problem.
And again, reminder here, we're live streaming this Probate Weekly. If you're watching this on the live stream on YouTube, Facebook, or LinkedIn, feel free to put your questions in. If you're watching on recording, put your questions in, and either I'll respond or I'll circle around to Paul as well to respond to those. One of the unique things that I saw you do is pet trusts. And I've seen, when you go to probate court, I used to go to probate court in LA County every day. You see people fighting over pets and who's taking care of them, what that means. I had a client whose nefarious ex-girlfriend claimed to be the caretaker for the pets as long as the last pet was alive. They had like 5 cats, 3 birds, 2 reptiles, and she created her own pet trust where she had access to the house as long as the last pet was living. But there are people who want to take care of their loved ones, including non-human loved ones. What are some unique considerations and opportunities for pet trusts?
Absolutely. You can, if you have a Fluffy or a Fido or whatever that you, and it's kind of important to do this, because if those animals are very likely going to outlive you. It's a good rule of thumb. Either one, you've either got to be very clear to somebody that you know that they are to take your dogs or cats. That way, you don't have to put it in a trust. You don't have to do that, but you need to be really clear that and have somebody that would take responsibility for that. Maybe your successor trustee is your son or daughter, an adult son or daughter is established, and they're just going to naturally, okay, your dogs and cats are just part of your personal property, and we're going to take care of them, and we're going to handle them. But on the other hand, you may want to actually specifically state provisions for those pets. And then what you do is we actually name the pet, and we provide a specific kind of a distribution to be held in trust for the amount that trustee potentially would have to, for food, for veterinary, all the expenses related to that, the life of that dog or cat or whatever it is. And if it's a turtle, it can be, it will outlive the successor trustee and the successor trustee. You may have to provide a lot of provisions for that, and then you name those people who is responsible to do that. You don't get a lot of, if you have this very high valued racing horse, you're very likely to get some sort of challenge in probate. That's not really a pet, but that's a high valued item. So what we're looking at as a pet is a valued item that you want to take care of in a specific way. You can name that through a trust.
Well, it also depends. Some people are pet people and some aren't. I mean, if I don't think it applies to me, but if somebody asked me to be their successor trustee, they were single, let's say, and they had a dog. I mean, there are people in life who would love that, would take care of the dog. I'm just not a dog person. Now, my wife is, so we have a dog in the house, but I'm not looking for any extra. So you want me to help you out with paper? Great. You want me to help distribute your assets? Fine. I'll do the work, but don't ask me to walk it a couple times a day and deal with all that. So I think it's one of those things where if you have specific requirements and you want the comfort of knowing it's taken care of, you have the chance to plan ahead and take care of it. I think that's the key thing.
Right. But we'd also know we would trust you, Bill, even though you may not be a dog person, we would trust you to recognize, okay, to take responsibility of the dog, to find a proper home for the animal, and and if you were the successor trustee, you would have access to enough assets, hopefully of the trust, to provide to that and just proactively do that. You could do that, but if you're an estate owner and a FIDO owner, and you want to make sure of who that is, you want to make sure that there's money in there, and it's not left to Bill, who really just doesn't like dogs.
I mean, I'm not abusive or anything. I'm just not going to spend the rest of my life taking care of somebody else's dog. It's just
absolutely not. Yeah.
And I'm not set up to. I live in Los Angeles. I grew up in suburban Orange County, where we had huge orchards and such. Great, run around, do your own business.
Well, that's a big horse area too.
Yes, yeah. I was in the Harbor Heights where they had horses, and so yeah, sure, have a dog, have 3 dogs for all I care. I live in Los Angeles. I live in a house. We don't really have that, and the dogs don't chase after the trash trucks and all the other delivery trucks. It's a different story. Okay, so again, if you have any questions, this is a chance. The purpose of this is not how to handle probate. The purpose of this for real estate professionals is here's how to enter in the conversation with your customers, be of value. It's my belief. Paul, you can agree or disagree. You're an attorney. You're entitled to your opinion. Anybody who owns a house in California should have an estate plan and hold title in the estate plan, typically a trust. Anybody who's married with kids should have some provision. What happens? How do you want your kids raised? God forbid, if you're not available. Which grandparents? My daughter's blessed in that her children have 2 sets of 2 grandparents, but which ones make the decision? What you don't want is to have them fighting over, well, I want the kid to go to this school, but they want to go to that school. Well, one of you is a guardian, one of you is not. You want to make sure you set up properly and have your plan so your plan is implemented. And so for us as real estate agents, we're constantly looking, how do I build my business? When we started this call today, there was an agent who's been in business 6 years. I think it was Cynthia. How do I get started to build my business? Well, one is learn these concepts for your area, I think Cynthia's in Tennessee, learn estate planning, avoiding probate, key concepts in your market area. Share that with your customers, begin the conversation, find the attorneys like Paul that service your area, create relationships with them so you create value for customers. That's what we're doing today. And this is really, it doesn't cost anything to meet an attorney, to talk to them typically at the right time and right place. And I'm hoping today's call is, I know I'm learning, I hope you're learning as well. And importantly, how to bring that information to your customers and such. So Paul, let's talk a little bit about the business of being an attorney, right? You're a practitioner. We've been talking about your legal expertise and how you do things, but at its core, you have a business that you own called Paul Hilton, the attorney. Paul, the attorney, is the main employee, but you have a business you have to run. So what are some of the, and I think, I've talked to you about this. I just want you to share what you're comfortable sharing and don't share what you're not comfortable, obviously. But what are the methods that you use to generate business? I know that, people know you, like you, and trust you, will send you cases. Do you spend time doing business development? Is that part of your workday practice or weekly practice as far as business development? And if so, what are types of things that you do?
Good question. Yeah, you go through a law school. You just kind of a little bit about my background too, and you can find this on my website. I was a government employee. I spent 26 years in the Marine Corps. I was a Marine Corps officer, and then I retired and I worked for the Department of the Navy doing information technology for the fleet. And it was in that period that I went to law school, so I never had to build business as a federal employee and as a military officer. Business came to you. You got your funding. If you did a good job, they refunded you. If they wanted somebody else to do it, didn't. So I went to law school to learn law. With the dirty little secret of law schools, they don't teach you. Yes, you have to get clients. That's the hardest thing. And it's probably, as real estate brokers, the things that you do too. I'm sure that's, oh yeah, how do you do that? And I had to learn that. And the best clients that I have are those that are referrals from the networking that I do. And I do a number of networking things. I've been in the North County San Diego Chamber of Commerce. I've attended events with them. I do one of the structured networking groups that meets, weekly, and they have to, you don't have to, you're supposed to give certain referrals out and meet other people. I found that that's very helpful as far as just getting your name out there. What I don't find, I haven't put a lot of money into it because I think it's expensive and is typically not very helpful, is, just advertising, even Facebook advertising and things like that. That's my general belief and experience. So I work on referrals. Met Bill. I'm working on a network, a veterans network, and so and it takes time. I've been doing this for 5 years since I graduated from law school and passed the bar, and it just takes time getting your name out there. People don't know you. People are like, oh yeah, Paul's an attorney. Oh, he could answer that question. Of course, then you get a lot of people, the cousin, the neighbor, the friend. Hey, let's ask Paul a question, and maybe we'll get some legal advice for free. So you gotta be careful of that. I don't know if that answers your question. That helps or not.
No, it does. I think we as real estate agents imagine there's some magical process that business just comes to attorneys, and the reality is, these ones I've met, the most successful, have a clear path, practice, process for generating business, as well as how they handle their business. And we as real estate agents, if we're looking to build relationships with them, should be aware of it and see where we can fit in, supplement, help those things. And obviously meeting more people is one of those. If you had a son or nephew that was starting off, or daughter or niece that was starting off in real estate and wanted to network with attorneys, for their business. What would you recommend them to do? Would you recommend them to go to the Chamber of Commerce? Would you recommend them to go to attorneys like bar associations as affiliates? What would you recommend them to do to meet with attorneys like you to develop those relationships?
All of it. I would. You really do have to do all. I would go to the those events, the chamber events. Those are really important. That helps you get to know the community and stuff like that. And then I am a big believer in the structured networking groups, and there's BNI, there's LaTip, there's Provisors, there's different ones that have different kind of, and they're a fee, but it's not a huge fee, yeah, and they are, they are as successful for you as you put into it.
Right.
They're really a thing you have to actually try to help others, try to you're looking for referrals for others and business to give to others. And then that's the way you get known. That's what that increases your credibility, your visibility, your credibility. And then, and then follow up and just continue to follow up and learn different ways to do that. Now, a lot of you do these, the newsletters and those things, those email networking sort of things. Those are all good, but they're better when you've actually made that warm introduction, either at a chamber meeting, a follow-up phone call, maybe met for lunch or something like that. And now you have a connection with this person, and it's not, oh no, not another, another email to delete or into spam. So that's, and I'm still working it. I'm still, I have ways I want to grow more myself. Before I hang this up, however many years from now too. So I'm still working it. Part of the reason I'm here today, because I met Bill, and I want to continue to build that relationship and meet others with it.
Thanks so much. So if somebody was interested, we have, I'm sure real estate agents, investors in San Diego, in the Inland Empire, Orange County, nearby areas you service. What would be the next step if they had a client who was interested in an estate plan or had a particular problem with a plan? What would be the best way to reach out to you?
Well, on my website is my email address. There's a contact information you can schedule through the little chat, the little Apex chat thing. There's actually somebody down there that you can do a chat with. You can call me at 858-240-6730. You will not get me. I do have an assistant now who will happily answer your question. Take a message. I will get back to you, and you can send me an email. Absolutely. That's and I'd love to hear from you that way. So the Apex chat is great. I always answer those. Those come up on my text when those happen through my legal assistant, through a phone call, or send me an email.
Fantastic. Well, look, Paul, I really appreciate taking time today to give us a wide tour of military families, estate planning in general, trust administration, and pet trust. So I really appreciate the breadth and the opportunity to share today and the education you brought to everybody. Thank you so much.
Well, thanks for being here. I did want to say at the end, when you do have these situations come up, do contact an attorney. Don't go back and say, oh, well, I had heard a podcast where Paul said this. Because every situation is more detailed and more specific. You really do need that advice and kind of thoughtful guidance from an attorney for that particular situation. And I'm happy to, if you reach out to me, anybody here on this phone call, just let me know you were on this podcast, and I'm happy to try to answer your questions directly.
Fantastic. And we'll put your contact info in the description below, or if you see this and can't find it for some reason, reach out to me as well. Paul, again, thank you so much for your time today. I appreciate it so much. And we'll look forward to talking again soon.
All right. Thank you so much, Bill.
And for the rest of you, again, this is Probate Weekly. We do this every Thursday at 4 p.m. Pacific time, 7 p.m. Eastern. We live stream it. You can sign up to come on the Zoom call at probateweekly.com. You can go to the YouTube channel. If you go to episodes.probateweekly.com, you'll see the past episodes as well as the most recent episode if you're interested in that. And then one other thing I just want to highlight is I have an upcoming real estate focused email mastermind class, because I find the question we started this call with Cynthia asked me, I don't know if you're still on, Cynthia, you want to continue that conversation. How do I build my business? One of the keys I find, having coached so many people on my team now, I have 43 agents on my downline in my team, is that they don't have the foundation on which to build their business, which is really your database and communicating with your customers, starting with your email. And so I decided to put together a kind of a low cost, it's $97, one-time call for an hour, is a Zoom call. We're going to record that, and then 4 half-hour follow-ups as a private Facebook group on how to, and the goal is to increase your contacts by 16 times, to double your contacts, to double the frequency of your contacts, to double the channels you're on, and double the effectiveness of your email. And if you do that 2 times 2 times 2 times 2 is 16 times more people you've been in contact with. I'll show you how I did that, how I get those results, and I'll share that with you. So if you're interested, that's in the chat box as well, or text or email me if you're interested. I'd love to have you join us for that. Again, I'm Bill Gross, at Bill Gross Probate on social media. Continue the conversation at probateweekly.com. Thank you, everybody, and have a great week.